30th was difficult. Okay, we'll see. Mr. Rohit, the trader, entered into a contract with Mohan for the purchase of 100 shares for a total consideration of 1 lakh. The agreement expressly provided that ownership of the goods, the ownership of the goods would pass to Rohit immediately, while the price was to be paid in 2 equal installments within 30 days. The goods were duly delivered in accordance with the contract. However, when the second installment became due, Rohit defaulted in payment and contended that since a part of the price remained unpaid, the transaction amounted only to an agreement to sell and not completed sale. On this basis, he refused to pay the balance amount. Examine the legal validity of Rohit's contention with reference to the Sale of Goods Act. What it is, people? Sale.
Ownership is transferred.
But
still
he is telling ownership is transferred now, but he said as the payment of price will be in 2 installments in the future, because of that, he is saying it is just an agreement to sell and not a sale. Price is irrelevant for the ownership is transferred. So the sale is made. Okay. So the exact answer was, people, if you guys remember, if the property in goods is transferred at the time of contract, it is a sale. If the transfer is to take place at a future time or object to some conditions, it is an agreement to sell. Thus, the distinction lies in passing of the ownership. In the former, ownership is transferred and the buyer becomes owner and must pay the agreed consideration. One more thing you can write here is, people, always remember, in a contract of sale, the ownership can pass immediately and the delivery can be in the future, the payment can be in the future, the payment can be in installments, and the delivery can be in installments. So that is what is the scenario. You guys you can also write that point. So it is all subject to the contract. If you guys want to transfer the ownership immediately, payment of the price does not decide transfer of ownership. In the given case, transfer of ownership happened with immediate effect. So because of that, people, it is not agreement to sell, it is contract of sale only. Because a sale has nothing to do with transfer of payment of price or transfer of delivery. It is irrelevant to decide transfer of ownership. Yesterday only we saw that. Agreed? So that is the answer here. Okay. See, since the ownership of shares has already been transferred to Rohit at the time of delivery, the contract was a completed sale. Rohit's contention that it was only an agreement to sell is legally unsustainable. He is bound to pay the balance of the price. Simple? Yes? Okay. Next one, Mr. Samir, a retail shopkeeper, purchased 10 cartons of packaged fruit juice bottles from Fresh Foods Limited, a reputed beverage dealer. The cartons were sealed and appeared to be in good condition, and therefore Samir accepted them without objection. Subsequently, when the bottles were sold to customers, it was discovered that several of them were contaminated with fungus, and a few customers even fell ill after consuming the juice, compelling Samir to issue refunds and causing significant reputational damage to his business. When Samir demanded compensation from Fresh Foods Limited, the seller refused, contending that the goods had been sealed and were accepted by him at the time of delivery. Examine whether Samir can succeed in his claim under the Sale of Goods Act 1930. What is the provision? Sale by description? Merchantable? So the main provision will go towards, people. See, purchase 10 cartons of packaged fruit juice bottles from Fresh Fruit Limited, reputed beverage. Okay, see, description, it is just an assumption. Description is not very evident. What is evident in the given cases? Whenever, people, remember, merchantable, We generally use it, people. It should be free from defects. Correct. But whenever it is edible items, we also write majorly wholesome. So if you ask me, the major provision has to be wholesome, but the institute has given an answer in a different way. Huh? Tell me. Description. Now they have to describe something like that, right? Now see, they're telling 10 cartons of packaged fruit juice bottles. Nowhere it is given that it is fresh, high grade, nothing, right? Appeared, right? It is appeared, not marketed or sold. It looks is what they are telling. Yes, Sam. See, description is simple. If you are describing it like that, then description will come into picture. So I would like to deviate with what Institute has said here. It said when goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. In addition, so according to me, this becomes the main provision, because I always tell you, in the case of edible items, it is always wholesome is what we use. Latent also you can do it, which is not, that is also hidden defects, something which is not visible to a normal eye. So that is also something which you can write 100%. Yes. Yes, sir. So that is what I'm telling you. There is an implied condition as to wholesomeness, that is, the goods must be fit for human consumption. Where such goods are harmful or dangerous to health, the buyer is entitled to reject them and also claim damages. One of the basic conditions is that goods must be of merchantable quality and also satisfy the implied condition of wholesomeness. It was duty of the seller to ensure that food products supplied were fit for human consumption. Hence, Amir is entitled to reject the goods, recover the price, and also claim damages for the loss suffered. Agreed? Yes, sir. Okay. Next one. Mr. G sold some goods to Mr. H for a certain price by issue of an invoice, but payment in respect of same was not received on that day. The goods were packed and lying in the godown of Mr. G. The goods were inspected by H's agent and were found to be in order. Later on, the dues of the goods were settled in cash. Just after receiving cash, Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. H did not take delivery of the goods, Mr. G kept the goods out of the godown in an open space. Due to rain, some goods were damaged. Referring to the provisions of Sale of Goods Act 1930, analyze the above situation and decide who will be held responsible for the above damage. Will your answer be different if dues were not settled in cash and are still pending? Risk passes with the ownership. So who will be liable? H will be liable. So what is the provision you guys are going to write? Risk passes with the ownership. That's the provision. And nothing else will come. Very good, Rakesh. That's one of the main provision you need to write. But who will be liable? What else provision you will write? Party in default. What exact party in default? Yesterday I told you in one place exactly where question will come. Whenever people, upon a sale, the goods are still with the seller or buyer because of the other person's defect or default. In such case, what did we decide? If you guys remember, I gave you an example. Ramana's Amazon, he attempted the delivery. Amazon, he did not take the delivery. Now, whenever the risk, the delivery date is pushed by buyer or seller, whoever is a party in default, he will be liable. Now see, technically the date of delivery is today. According to me, I have clearly told you have to take. But you did not take the delivery. Agreed? Now after that, the goods are still with me. Remember, they are telling you, whoever is a party in default, he continues to be at risk. But you have other point also which you wrote. What is that? That doesn't mean whoever is having the goods, I am not the owner of it, correct? Now technically, I should have given you the goods, I have given it. I have, as a bailer of the goods, as a bailee of the goods, your goods are with me now. It is my duty to take reasonable care of the goods. Now both the points has to be written. Now in the given case, is the reasonable care taken or not? Is it taken? No. Now try to see. That's why I always say they will help you in the question only. What have they said? The goods were packed and lying in the godown of Mr. J. The goods were inspected and everything is done. Later on, the dues of the goods were settled in cash. Just after receiving should be shaken and goes on. Two. That means what, people? Don't you think even I have my own business? I have other materials coming in. If I keep your goods there, then when will I do my business? Imagine if at all, because you did not take it on time, I might have lost some opportunity of making some money because I did not order new stock. For that, will you pay compensation? Right? Now, people, what did he say? He gave you a reasonable opportunity. Any person who do the same, no, people, I will first treat my goods. I gave you an opportunity also. Now, if you did not take it out, then I have to keep it out. I have other stock to come. So, as a bailee, he has taken reasonable care of the goods. I getting the point? Because when there is no other place, then what do you expect? Do you expect me to keep your goods inside and my goods outside? You tell me, which brain person will do that? Hello? Agreed? Yes, sir. That is what is the answer. Whoever is the party at default, they will be at risk. If at all there is a delay in delivery, whoever is the party in default, they will bear the risk. Next one, but that does not discharge your duty as a bailee. As long as you are taking reasonable care of the goods. What is reasonable care? Whatever an ordinary man would treat as the goods are his own. He has taken that care because he has his business to run. That is the maximum he can do. Hello? Done now? We'll see what they have said. According to them, when the seller is ready and willing to deliver the goods and requests the buyer to take delivery and the buyer does not within a reasonable time after such a request, he is liable to the seller for any loss occasioned by his neglect or refusal. Correct? Hello? And also for a reasonable charge for the care and custody of the goods. Risk of goods prima facie follows the ownership. Goods remains at seller's risk unless the property therein is transferred to the buyer. But after transfer of property, the goods are at the buyer's risk whether delivery has been made or not. Agreed? You saw yesterday's mic example. I have given the mic to Ramana, but it is still with me. The risk is with the Ramana only. Once the ownership is transferred, who has the goods is irrelevant. Agreed? Yes? Okay. In the given case, Mr. G is already intimated, and because of the people, G should be borne by Mr. H. If the price of the goods were not settled in cash and some amount would have been pending, then Mr. G would be treated as an unpaid seller and he can enforce the following rights against the goods. We'll see this. What is this? I think unpaid seller had not done it yet. No? Sorry. Okay. Leave that. It's okay. We have it. Today's unit will be doing it.
So you will sell it, right? Probably.
Unpaid seller, the buyer will get a right to sell it to someone else.
Sell it to someone else.
We have a right to resale, it's called.
Yes, right.
Okay. We'll see that. Today we have it. What is unpaid seller? I'll tell you. Samuel purchased a television set from Arun, the owner of Gada Electronics, on condition that for the first 3 days he will check its quality and if satisfied he will pay for that, otherwise he will return the television set. On the second day the television set was spoiled due to an earthquake. Arun demands the price of television set from Samuel. Whether Samuel is liable to pay the price under Sale of Goods Act, who will be ultimately liable to bear the loss? So whenever now what will you write? What will be my provision? My provision is people. Section 24, which talks about sale or return basis. In sale or return basis, when will the ownership pass? Buyer accepts the goods. If he keeps the goods beyond the reasonable time, he does something equivalent to an acceptance. Now in the given case, none of it is done. Agreed? It's still the second day. Now people, that means what? According to the rule, risk always transfers with the ownership. Now the risk, that ownership is still with the seller because buyer has not yet given his consent. Agreed? Then what is the responsibility of the buyer here? The responsibility of the buyer here is nothing but people, bailer, bailee. I am a bailee. So I have a duty to take reasonable care of the goods. As long as I am taking reasonable care, I am discharged. In earthquake, we saw the same example also yesterday. What reasonable care I can take? Now people, because of that, I am free from my liability as a bailee also. So in the given case, who will be liable? The seller will be liable. Understood? Yes, sir. All of you? Okay, that is the 50th. Oh, sorry. Okay. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed to Akash that he can take the delivery of wheat from him, and till then he is holding wheat on Akash's behalf. Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price on the contention that no delivery has been done by seller. Whether Akash is right with his views under Sale of Goods Act. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. So he is purchasing, correct? Okay. Bhaskar says that wheat is in his warehouse. That means there is a godown. It is there, it seems. And that godown is taken care by a person called as Kishore. He is called as a warehouse keeper. Kishore has confirmed to Akasha that he can take the delivery of wheat from him, and till then he is holding wheat on Akash's behalf. That means, sir, my owner has told me that you can come and take the goods. Until then, I will hold it for you. You don't worry. I'm taking care of the goods. Now you understood the scenario, no? And now try to think and tell. What has happened? Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price in the contention that I have never taken the delivery at all. It is still with you guys. I have not taken the delivery. He is saying delivery didn't happen at all. It is with you guys only. So I am not liable. Liability is on you. I am not liable is what Akash is telling. Now they are asking your opinion. What is your opinion? Symbolic delivery? Why symbolic? It is constructive delivery, people. See, types of delivery. There are 3 types of delivery. One is called actual. When a product is taken, kept in your hand. Symbolic delivery. A product cannot be kept in your hand. We give something else as a token of transfer of something else. To give a car, you give a key. That is called symbolic. The third one is called as constructive delivery. What is constructive delivery? I told you also. The custody, wherever the product is, it will not even move 1 inch. Wherever it is still there only. Then in constructive delivery, how does the delivery happen? Delivery happens through acknowledgement. Someone calls you and says, sir, the product is received, or the product, I'm going to hold it for you going forward. Someone acknowledges that. Now the way Kishore said, sir, you can come and take the goods. Until then, I will hold it for you. He has said on behalf of Akash. That means what? The goods did not move even 1 inch. But the delivery has happened. Why? That is what is called constructive delivery. In constructive delivery, delivery happens through acknowledgement. That's the word you need to write. If acknowledgement word is there, you guys will get a maximum marks. So 2 words that the valuer will look for. One is constructive. Next one is acknowledgement. Hello? If these 2 words are there, you will get maximum marks. Is this clear, all of you? Yes? Clear? Understood?